The Mountain West, as we knew it, is done. The basketball and football seasons are over, and now we embark on a new era where there are two conferences in the West Coast in the group of six. Let's talk about the lawsuit, the fight, and why won't these people just settle this lawsuit already? Let's break it down. This is the Let's Run podcast. What is good, my people? Welcome to the show today. Grateful to have you be a part of the Let's Run podcast. Please, while you are here, like this video, subscribe to the channel as we continue to climb. Grateful to have you. I appreciate you all as I've kind of dealt with this burnout issue with the podcast, but I'm grateful to have you be a part of the show. Wanted to talk about an update and kind of, every once in a while it's good, whether it's in a relationship or whether it's in anything really, just to take inventory of your position. Kind of look around, see where you stand, whether that be at work or as a basketball or a football team. And I think it's important that we take inventory as to where the Mountain West stands in this lawsuit and where the Pac-12 stands, as both of these conferences begin a new era. And a new, it's really uncharted territory having two group of six schools in the West Coast. We haven't really had that since the collapse of the WAC. It's been about 15 years. And so we're entering uncharted territory. These are interesting times, and this lawsuit still hangs in the balance. At this point in time, there have been multiple filings by each party. I went over kind of what's been going on. There was a new filing that was before the court, and I guess I'll open this up. I want to thank some people that actually sent it to me, and I ended up finding it online. If you look for it on the docket, you can find it. But I'll show you kind of what it looks like. We can talk about what exactly it means. I am an attorney here in Nevada. Been an attorney for 5 months now. Really enjoying it. Obviously, none of this is legal advice, just kind of my opinion about what's going on. This is really interesting. And to be honest, neither of the parties seem to be able or seem to have established kind of a strong position. And that's not to say that the parties are in bad positions, but I don't see right now, based on my read of the situation, my view of the situation, that either of these parties has, taken control or gained significant leverage over the other. So this is what the court order actually kind of looks like. It's a discovery dispute. Now, what that means is after a lawsuit begins, generally at the very beginning of a lawsuit, you will see one of the parties. This is how every lawsuit begins. One of the parties files a complaint, which is what happened. The Pac-12 conference is, at least the plaintiff in this case, and the Mountain West conference is the defendant. In the other case, obviously, there are two legal cases. We kind of talk about them as they're one, even though they are distinct legal cases. The one about the Pac-12 and the poaching fee, and then the one about the exit fee with the departing schools, with San Diego, with Utah State, Colorado State, and Boise State being the ones that brought that lawsuit. And so this document only references that lawsuit between the Pac-12 and the Mountain West by themselves. It's not about the exit fees. And this is a discovery dispute. Now, what that means is once, like I said just a moment ago, once a complaint is filed, generally parties will file, especially early on in cases, motions to dismiss. Now, you kind of have to, if you're responding, so say you're the Mountain West in this position, before you can actually answer a lawsuit, you have to try and get a case dismissed. They're called 12b6 motions. And what that means is before you even answer a lawsuit, you go to the court and you say, this lawsuit is completely baseless and it should be dismissed right now. The Mountain West tried that. And oftentimes, in cases with this much money, at stake, it's pretty unlikely that you're going to get a motion to dismiss this early on, especially when there's so much communication. There's a lot to this case. And so the court, the Mountain West went to the court back in, I believe, September and said, hey, you should dismiss this case right away. There's nothing here. The court said, no, there might be something here. Let's let this case go forward. And once that happened, the Mountain West obviously filed their answer, and we were in litigation. That's pretty expensive. Litigation costs. It should be said that the litigation cost for this, now, nobody really knows what their rates are. Each of these parties has, I doubt that they're all hired, they're all handling it in-house, with in-house attorneys. Obviously, the Pac-12 has a couple of attorneys, and the Mountain West has a couple of attorneys, but they've probably outsourced this. In fact, maybe it's here at the bottom. I don't see it, actually. I was looking for a certificate of service. but they've probably outsourced this to kind of bigger law firms, each of them. And, the cost of this litigation, now, if there's something like a motion that's being filed by either party, you could be looking at, more than $1 million, a month in litigation fees. If it's just kind of a normal kind of slow discovery month, where the parties are just exchanging documents and evaluating claims, you could be looking something, in the $300,000 to $400,000 a month range. But the point I'm getting at is both of these conferences are spending, 500,000 to $1 million a month on these legal fees. That's very expensive for each side. And the further this drags on, it's just going to be a big hole in the pockets of these parties. So a discovery dispute is after we do all the things that I talked about, filing a motion to dismiss, an answer, a complaint is filed first, then usually motions to dismiss right at the beginning of the lawsuit, 12b6 motions to dismiss, and then we jump right into an answer and then discovery. And discovery is basically how the parties exchange information in the lawsuit. Basically, at the beginning of the lawsuit, the parties kind of line up and they file these things called requests. Now, there are different types of requests. I won't go too into detail about this, but it seems to be the biggest thing in dispute here would be a request for production of documents. You can do interrogatories, requests for admission, and this dispute is about a request for a request for production of documents. Now, the Mountain West, there's other things to this too. The Mountain West obviously sought to file counterclaims against the Pac-12. Only one of those counterclaims was actually dismissed. A counterclaim is basically when one party sues me, and then I sue a party back, and I say, actually, wait, you're suing me. And I'm not going to get too into the counterclaims part. I kind of wanted to talk about the discovery part of this, but essentially, the Mountain West had a counterclaim for fraudulent inducement, basically saying, hey, you told me you were going to fulfill this contract and got me to sign it when you knew full well at the time that you weren't going to fulfill the contract. It's a very high standard in court to actually get. And so, that fraudulent counterclaim, that fraudulent inducement counterclaim was dismissed. Otherwise, the counterclaims and the claims by each party are still there. And so that's kind of a nothing burger to me. Obviously, the Mountain West had fraudulent inducement as one of its actions. But in terms of the discovery dispute, the Mountain West essentially was trying to say that they didn't have to search for documents held by officials at member schools. The Pac-12 wanted the Mountain West to search for kind of electronically stored information for each of its schools. The Mountain West argued it didn't have control over those individuals because they work for separate schools, not for the conference. The court really, honestly, kind of rejected everybody's arguments in this and drew a narrower line based on the Mountain West bylaws. And they basically said, look, there are certain documents, Mountain West Conference, that you can get that are fair to that are fair to you, that are fair to ask for. And the court basically said to the Mountain West, I mean, calling this a loss isn't a really big deal. It's not really a loss. It's definitely an annoyance for the Mountain West side. It's not really actually related to the claims. But the Pac-12 basically won in this and got an order requiring the Mountain West to search and produce responsive documents from the emails of board directors. And obviously the Pac-12 wants this information because it wants to kind of prove the intent and the comings and goings of the Mountain West board members when these agreements were being signed, when the conference split was being negotiated. And it's definitely a win in terms of a discovery dispute. It's not really related to the claims of the case. The Pac-12 didn't get an order requiring the Mountain West to search athletic director files specifically. The court found no basis to say that athletic directors have a role in running the Mountain West such that the conference has control over their documents. And the Pac-12 also can't enforce the Mountain West to search for documents of member school executives generally if they didn't hold a board or officer role. So it's really only limited to the people on the board of the Mountain West. It's not crazy broad. It's a narrow victory for the Pac-12. And again, this isn't really about the merits of the case. This is all just, saying like discovery disputes, essentially. And my thing is like the Pac-12 could get a lot of this information by subpoenaing the records of the schools directly. It's basically sending a request to the schools, a lawful request that they must produce information, correspondence, communications from the times that the poaching agreement was signed. Practically, the Pac-12 is going to get an easier access to discovery material from the top level conference decision makers. So think about, the board of directors of the Mountain West, your presidents of UNLV, your presidents of Wyoming, your presidents in New Mexico. The Pac-12 has more access to to their communications than it did yesterday. Um, and honestly, like this will drive up costs and kind of the burden on these Mountain West athletic directors. So it's definitely like a victory for the Pac-12 in that sense. The Mountain West, arguments that it lacked control over the documents, it didn't really find it didn't really find a lot of merit in that, the court. And so practically, is it a big deal? Yeah, I mean, it's a big deal. It's certainly a very big annoyance, and it'll drive up costs for the Mountain West. So calling it a victory for the Pac-12 is fair. And I don't know if the Mountain West thought that they were going to win this motion. Often, they were going to win this discovery dispute. But the point that I'm trying to make here is the parties are posturing really hard right now, and neither party has shown any sort of willingness, from what I understand, to come to the table and negotiate a number that both sides could agree on. And that probably is because, in my view, there is no number that both sides could agree on right now. There is no number that the Mountain West would be willing to take that the Pac-12 is willing to pay. That doesn't exist right now. And so kind of as we move towards this later phase of litigation between the parties, we'll see if the discovery disputes continue. We're going to see what the tactics of these lawyers are. It's in a stalemate, and each side can get little victories. The Mountain West keeping its counterclaims outside of the fraudulent inducement as part of the lawsuit, that was a win because the Pac-12 filed a motion to dismiss those, the Mountain West counterclaims. And, the Pac-12 can win a victory where it gets easier access and a burden on the Mountain West to produce discovery documents. These parties are in a stalemate right now. And, once we once we get a little further on into discovery, I don't know if they have been doing depositions already. I don't know kind of what phase of discovery they're in. I know that, there's obviously been, requests for production of documents, interrogatories, which are basically questions that you send the other side that they have to answer under oath. Those things have definitely been exchanged at this point. But it's a stalemate right now, guys. I don't think either of these parties are budging really at all. And upcoming, the Mountain West is going to owe a payment of roughly $14 million to schools like Air Force and UNLV. And I think around $7 or $6 million. I can't remember the numbers precisely off the top of my head, but the Mountain West is going to owe, per its contract, a lot of money on July 1st to the schools in the conference that remained behind. And certainly, it depends on how the Mountain West is, keeping their money, if they have the money to make those payments. Certainly, there is no scenario. It's not for several years. There's no scenario where, and you'll see people posit this all the time, what if the Mountain West can't pay UNLV and Air Force? They'll just bolt to the American and Pac-12 respectively. That's not going to happen. The Mountain West has a grant of rights that locks in these schools regardless of the outcomes of the lawsuits. The schools will probably be annoyed that they have to wait for money longer. The Mountain West is going to win enough money to at least pay these schools probably that initial payment. Specifically, not necessarily even from the poaching fees, but from the exit fees. I mean, look, the Pac-12 probably has more of an argument. As you've heard countless times, the Pac-12 has a stronger argument on the poaching fees. And the Mountain West certainly has a very strong argument on the exit fees. And so, look, UNLV, Air Force, New Mexico, San Jose State, these schools are going to get paid. It may take longer than these schools want, but, even if they don't get paid, the legal document and the grant of rights that these schools sign with the Mountain West is pretty ironclad. You're not going to get out of it. Likewise, the American schools, they've been pretty public about their rebuke of the Pac-12, and that kind of puts the Pac-12 in a tough position. They can't really expand. The Pac-12, smartly, by the way, they shouldn't be looking to expand and just add anyone. They're not going to just take Sacramento State. They're not just going to take New Mexico State. They're not going to take, and really, if you look on the West Coast, that's pretty much their options. They're not just going to take anybody. The American was pretty aggressive in its expansion to Texas, and I don't think the Pac-12, is going to take anybody else, take anybody out of Conference USA either. So this is the position the Pac-12 is in. They don't have anybody they can add. These conferences are just in a stalemate. And I assume that it's going to be like that. To be honest with you, I think we could be looking at just a couple of years of a stalemate between these conferences. And really, it's going to come down to winning on the football field and on the basketball court. And, obviously, you favor the Pac-12 on the basketball court. You favor Boise State as the leader of the Pac-12, definitely on the football field. But, the Mountain West schools are saying, let's play ball, let's compete. And so, these lawsuits, it's hard to say how they're going to turn out. There are small victories for each side. And for an update, there's really not a lot to say. It's just that each side is winning small victories here and there. They're in litigation, and I would be shocked if this case settled before that July 1st deadline. I think especially on the poaching fee case, I think that the Mountain West and Pac-12 might just kind of death stare each other down and really go for it. On the exit fee case, it's going to depend on the appetites of the schools that are leaving. Are they cool with leaving behind all of their revenue? If Utah State, Boise State, San Diego State, if those schools were cool with just saying, all right, we're not going to pay you anything, but you can keep what you've taken from us, I think the Mountain West would be happy with that outcome. And they should be. That would be like $100 million or $90 million plus the Mountain West would win in that case. So, it's kind of a tough position, and it's a stalemate, and I guess we'll see. But guys, let me know your thoughts. I wish that I could come here and say, oh, the Mountain West is crushing the Pac-12. And I wish that I had something as dramatic and as interesting to say as the Pac-12 is crushing the Mountain West. But that's just not the case right now. So let me know your thoughts in the comments below. I appreciate you all. Have a wonderful night, and let's run.